The Act defines a vagrant as someone of no fixed place of abode or means of support, or an individual who wanders from place to place, often maintaining themselves by begging or other disreputable means. The Act was designed to provide support and rehabilitation to vagrant individuals instead of criminalizing vagrancy. The rationale behind the rehabilitative approach was to prevent repeated cycles of arrest and incarceration, which do little to help individuals reintegrate into society experienced in African jurisdictions and indeed other jurisdictions elsewhere. Now, our response to the human rights issues raised by Human Rights Association petition is as follows. The Act is not inconsistent with the Constitution of Zimbabwe, given that its provisions neither violate the right to dignity nor freedom from torture, inhuman, and degrading treatment. It should also be highlighted that the petitioners are also challenging the same Act before the courts. The Act is a law of general application and is not designed to be arbitrary or targeted at specific groups. The vagrants law in these jurisdictions meets the set conditions for limitations provided for in Section 86 of the Constitution. Therefore, our view is that it is a fair, reasonable, and necessary piece of legislation. The Act was designed to assist and capacitate vagrant adults and is not intended to infringe on any children's rights. Section 17 of the Act is clear that the Act does not apply to persons below the age of 16 years. At the time of enactment, children were persons below 16 years. Therefore, it means that the original intention of the Act was to assist vagrant adults and not children. There is therefore a need to align the Act with the Constitution by raising the age under Section 17 to 18 years. Moreover, the Children's Act, Chapter 5.06, provides for the protection and welfare of children, including those who are homeless. The legislature in the Act was not to punish these individuals, but to ensure that they are empowered with alternative skills to make a living from and to be economically productive. The maximum period of detention in a re-establishment center provided for in Section 13 of the Act is to ensure one will have the required skills for economic survival and to ensure that one has received proper psychological social support for reintegration into the community. Justification of maintaining the legislation. Maintenance of law and order. The Act aims to maintain law and order by addressing behaviors associated with vagrancy, such as begging and loitering, which can sometimes lead to petty crimes or disturbances such as drug and substance abuse. And I'm sure we are all aware of the problem we are now facing as a nation, and the leadership in the country has been highlighting and addressing these issues. Given the link between drug and substance abuse, crime and vagrancy, individuals who are homeless may turn to drugs and substance abuse and crime as a coping mechanism for the harsh realities of life on the streets. The Act is a vital cog in fighting drug and substance abuse and crime by removing these vulnerable persons from the streets. These individuals are rehabilitated and consequently the state can ensure that society is safe. The case of Tandowen Kosingov 20 alias Sauro, who was arrested in connection with 5 cases of murder which occurred in Harare between 20th of August 2023 and 24th September 2023 highlights the dangers of repealing the Vagrancy Act. Furthermore, if the Vagrancy Act is not managed, it can negatively affect the economy of the country. It is to be noted that the presence of vagrants in the central business districts, especially close to hotels, as is the case at Monomotapa Hotel, and I'm sure we are all aware, has negative effects on tourism and the right to safe movement of the public. Rehabilitation and support. Although the Act has measures aimed at rehabilitating vagrants, some groups are now interpreting these measures as punitive. Section 7 of the Act provides the minister with power to establish rehabilitation centers where individuals are afforded the occupation, instruction, or training requisite to fit them for entry or re-entry into or return to regular employment and into society.
Establishment centers. I think we did not get the response to that. Do we have these establishment centers for the migrants?
Yes, we do. And they fall under the Ministry of Public Service and Social Welfare.
Maybe Honorable Chair to say maybe it was a mistake on our part. We should have had a list of those. But I'm aware there's one in Highfields, but this is for memory. But we will get the list and make it available. Apologies for that.
Sec has already said that you'll get a list. It's important maybe that we get that list, or maybe also clarify why these establishment centers are under the Ministry of Social, considering the Act directs the Ministry of Home Affairs to establish these centers. But outside of that, I wanted to understand, do we have statistics in terms of the number of vagrants that have been arrested? Maybe if we can get just brief statistics as to those who were arrested and their classifications, to say those who were deemed vagrant were basically touts, were they just beggars? I think that's important.
Thank you, sir. Let me indicate that offhand we are not able to provide the statistics, but we can provide the statistics after checking our records.
Basically are seeking a means of survival. And that's in an honest way. You can't criminalize that. What is simply required is organizing the vendors or the touts. That is what is required. And I'm sure there have been several initiatives. So we can't criminalize vending. In other, well, you can call it the best. Look what we've done in Mariam. If you go to other developed countries, along say First Street or Second Street, vendors will be organized. So we can't criminalize that. Maybe the issue came, maybe there was a perception that is disreputable. Disreputable is when people with Uber and other social ills, what do you call it, illegal gambling, things like that. Those would be what we would consider as, undesirable. But vending and touting, no, that's not our view. All we need to do is to have them properly organized in designated places so that we address the health issues, sanitary issues, and other, and obviously taking a whole of government approach. Yeah. Then, if I may, the Act came firstly in the 1960s, and we all are aware of what the situation was in the 1960s. But it was then meant to control the black population. But after independence, I think it was amended in 2016, and published 2017, and there was a recognition then, I believe, that we needed to change in an era where human rights and the need to be considerated were taking priority. So if there are any deficiencies in our responses, it's no excuse. You will appreciate that at times we are not ahead in terms of reviewing the law, and obviously, as the Deputy Commissioner General was explaining, and as my legal colleagues will explain, we've just been following that, but there is room for improvement. I thought I should just, well, definitely there will be deficiencies in when you ask us what you determine. Some of the issues would only be assisted by following the law, and if it is not amended to a point where there is clarity, particularly in terms of human rights, then it becomes a bit difficult. I think you will Honorable Chair.
On arresting vagrants, how does the police officer determine who to leave vagrant? Because as far as I'm in Harare myself, I see them all over. And at one point I came to the committee and said, there was a foreigner who was on one of the streets, attacked by young men, and until he lost everything. Right, but the police were not there at the time to rescue the white man. Nevertheless, when they are arrested, what do you look at?
Thank you very much, Honorable Member. I think the definition is given in the Act of what we determine as a vagrant, a person of no means, a person who's wandering around, no fixed abode. Those are the people we are referring to, and these are the people who do not have any means along the streets for their livelihoods, who end up committing petty crimes as indicated by the Permanent Secretary. And it is easy to determine that these are the vagrants, and they are supposed to be not arrested per se, because according to the Act, the Vagrancy Act, there is no penalty for arresting someone for being a vagrant. The penalty which is provided for in the Act is under section 4, where someone harbors a vagrant from being taken to a place of need. It's the only penalty which is provided for by the Act, I think.
Service, Labor and Social Welfare is doing Home Affairs. So please, Mr. Chairman, Honorable Chairman, can they respond?
Let's allow the PS to respond. Indeed, Honorable Chair, the honorable members are right in ascribing that, was apparently I'm being advised the Act itself, it gives the responsibility to the Minister of Home Affairs. But in practice, it's something else different. Why do I say so? Even in the structure that I have in the ministry, there isn't that expertise. We don't deal with that aspect except the police element where they go into the streets to then, should I say, arrest, for lack of a better term, the vagrants. But that there is a department and policy guidance within the ministry as it currently obtains, even in terms of structure, there isn't that expertise. That expertise of the rehabilitative lies elsewhere in the Ministry of Labor and Public. So really, it's something that's glaring now that we've appeared before you.
Now my question is clarity. Through your chair.
So, I didn't hear you. You said what did now.
Chair, thank you, Honourable Member. Let me indicate that where we go out to identify these people are identified and they're rounded up, normally we communicate with the social welfare because they are the ones with the facilities of handling these people. With the ministry and the police per se, we don't have the facilities to handle them. As you are rightfully indicating that there is a gap problem which needs to be addressed. We take them to social welfare where they are taken care of, but we know that the Act provides that these people are they are supposed to be rehabilitated. Unfortunately, at the end of the day, we are not able to follow up with the social welfare to see if they were rehabilitated. As we would have completed our responsibility by ensuring that they are moved to a place where we know they will be better taken care of. I thank you.
Basically are seeking a means of survival. And that's in an honest way. You can't criminalize that. What is simply required is organizing the vendors or the touts. That is what is required. And I'm sure there have been several initiatives. So we can't criminalize vending. In other, well, you can call it by the best. Look what we've done in Zimbabwe. If you go to other developed countries, along say First Street or Second Street, vendors will be organized. So we can't criminalize that. Maybe the issue came, maybe there was a perception that is disreputable. Disreputable is when people Uber and other social ills, what do you call it, illegal gambling, things like that. Those would be what we would consider as, undesirable. Vending and touting, no, that's not our view. All we need to do is to have them properly organized in designated places so that we address the health issues, sanitary issues, and other, and obviously taking a whole of government approach. Chair. Then, if I may.